Assalamualaikum and hi, we are from Group 1B. I am Nura Adra binti Hamid. Together with me, Nur Najai, Nur Diana Husna and Fazilatu Ardiana. Today we will be presenting on Draft Royalties and Public Authorities Act 2021. Royalties and Public Authorities Act 2021, known as Act 111, is an act to provide new laws for the offences carried out by the royalties and the public authorities of Malaysia. It was enacted to regulate the moral and etiquette of the royal families and the public authorities on their actions and also to give power to the court to elect the commission. Next is arrangement of sections in this act. There is 6 parts, which is the first part is preliminary, the second part is general explanation, the part 3 is offences and punishment, part 4 is power of search, seizure and arrest, part 5 is inquiries, and the last part is remedies. First, preliminary. Punishment of offences committed within Malaysia, meaning that every party that is subjected under this act shall be liable to punishment under this act. Punishment of offences committed beyond but which by law may be tried within Malaysia means any person liable by law to be tried for an offence committed beyond the limits of Malaysia shall be dealt with according to the provisions of this act. Moving on to general explanation, where I will be explaining on each interpretation. First, royal bloodline. A royal descent from a previous or current monarch, meaning that a royal bloodline that is net in line will be rule the monarch. Conference of Rulers, also known as Majlis Raja-Raja, will decide on the matters of religious matters, occasion or events performed for the benefit of the Federation, as Yang di-Pertuan Agong is the head of the religion. Public authority is known as government servant or legal person performing public administrative functions. Next is transparency, which means that the public authority will be held accountable for any offences committed. Court is held by a body of judge which is empowered by law to act judicially. Next is judge, which is a person who is officially designated as a federal judge, which is the person that will give the rule to the cases. Wrongful gain is any property that is gained by unlawful means, which means it is illegal. Dishonestly is anything done with the intention of causing wrongful gain or wrongful loss to another person. Remarks is a comment or saying that tainted the sovereignty of Malaysia and the image of Islam as the religion of the Federation. Illegal activities is illegal activity against the penal code which can be convicted, and private business is private company with private ownership. I will pass to the next presenter.
Thank you, Atira. So next, for part 3, under the offences and punishment, we draw 4 sections, which are firstly, private businesses. So under this section, any parties subjected to this act who are found to have wrongful gain by running private business or businesses when they shall not have any shall A. Circulate the profit gain to the country and B. Terminate the business immediately. Moving on to the section 16, which is personal interest. Under this section, any party subjected to this act who acted against their responsibilities for the personal interest where such act only benefits them shall be subjected with imprisonment for a term which may extend to 10 months or fine not less than 50,000 ringgit Malaysia or both. To give illustration regarding the term personal interest, using the current pandemic situation, A used his power to illegally gain vaccine without proper administration by the government, or B, who is a family member of a minister, was accused for not abiding the laws in Malaysia, such as interstate travelling. Next, for the third section, which is negative remarks, any party subjected to this act who leave negative remarks either orally or written shall be subjected with A. Public apology, B. Community service up to 720 hours, and C. Fine not less than 100,000 ringgit Malaysia. This section is focusedly aimed for any negative remarks regarding the sovereignty of Malaysia or any negative remarks to the belief of Islam. This is to protect the sovereignty of nation and also to apply the Islamic jurisprudence where the faith or the teachings of Quran shall be free from any misguided remarks. For example, A uploads a picture of a woman being the imam in a prayer with male as her makmum, which is prohibited or haram in Islam. Thus, we believe that drafting such section is vital to implement the concept of Islamic jurisprudence and to punish every citizen of Malaysia without exception. And not to mention that, according to Article 3 of Federal Constitution, it is stated that Islam is the religion of federation. For the last section under this part, which is criminal offences, it stated that any party subjected to this act who committed any criminal offences shall be subjected and punished according to the penal code. Next, I pass to Faziratu for part 4.
Thank you, Nurla Husna. So I'll be presenting the part 4 of the Acts, which is the power of search, seizure, and arrest. Whereby in this part we have 4 sections, which are section 19, 20, 21, and 22. On section 19, we have that whenever it appears to any RPSC upon information and after such inquiry as he thinks necessary that there is a reasonable cause to believe that in any premises there is evidence of the commission of an offence under this Act, he may, by warrant acquired from the High Court, directed to any police officer of or above the rank of inspector, empower the officer to enter the premises by force if necessary, and there to search for, seize, and detain any such evidence. However, there is an exception under this section whereby this section shall not extend to any case in which it involves the conference of rulers. Next, on section 20, we have the obstruction of search, whereby a person shall be guilty of an offence if he assaults, obstructs, hinders, or delays any police officer in effecting entrance to any premises under this Act or in the execution of any duty imposed or power conferred by this Act, or fails to comply with any lawful demands of a police officer acting in the execution of his duty under this Act shall be liable. Next is section 21 about the complaint, whereby any individual or relevant person may make a complaint in writing to the RPSC about an action, practice, or request that shall first specifically detail the complaint. Second, the detailing that what has been done or engaged in or being done or engaged in the complaint. And last is issues that have been raised by the public. The last section in this act, in this part is section 22, whereby RPSC shall carry out an investigation raised by the complaint of the public notwithstanding, whereby in this section stated that where the public has raised an issue that involves the royal and the public authority, RPSC without any exception shall carry out an investigation notwithstanding with the status of the royals and the authorities. In any such case arise, the provision of this act shall prevail and the decision shall be brought up to the court. Next, I will pass to the last presenter, Nur Najat.
Thank you, Fadziratul, for the previous section. And I will be explaining on part 5, which is the inquiries. There are three sections divided into inquiries, which is the appointment of the commissioner, duties and power of commissions, and the conduct of investigation. In section 23, it explained the appointment of the commissioner. The judges may appoint the commission RPCA under this act, which stands for Royalties and Public Authorities Commission. The appointment of the commissioner is one way that we can adapt from the Western jurisprudence to resolve matters that are concerned with the public. In section 24, duties and power of the commission. Commissioner shall inquire and start investigation when it is reasonable, as in when the commissioner deem fit to do so, and the public has signed the petition to inquire about such act. Commission may carry out investigation of situation when royals and public authorities committed offences in Part 3. Situation which affects the public perceptions to the royal and public authorities. In Section 25, by means of the conduct of the investigation, before the investigation start, the Commission shall inform the public that the matter is being investigated through press statements. The Commission may, for the purpose of an investigation, take the public opinion of the public into consideration before conducting the investigation, and the complaint shall be done through a formal report to the RPCA. They shall also consider the submission made by the royals and the public authorities. The result of the investigation shall be exposed to the public once ordered by the court, and any arising issues will be cleared out to maintain the dignity or to prosecute the royals and public authorities. Moving on to the part 6, which is the remedy. It is a remedy given to the public and also to the government. In Section 26, a remedy given to the public which explained that the power of the court to order RPCA exposing the outcome of the investigation. It is considered to be one of the remedies as the public deserve to know the outcome of the investigation because they do play a part for the complaint of acts done by the royals and the public authorities. Meanwhile, in Section 27, which is the last section in this act, if a royal bloodline are caught with the legal activities, any monetary benefit shall return to the state. But if public authorities are caught, the monetary benefits also shall return to the state property, and 50% of their monthly wage shall be deducted accordingly. I think that's all from us.